Yes, may I please your lordship. My lord, Article 32 contempt case. This matter, my lord, in fact, my
Order has been
my lord,
complied.
complied.
Mr. M. Islam, learned counsel for the petitioner submits that the order of the court has already been complied with and therefore this contempt case be closed. Taking note of the submission of Mr. Islam, learned counsel for the petitioner, this contempt case stands closed.
My lord.
Yes, I have
Highly
with
obliged,
regard to item 25, Lordship. Lordship,
Yes.
I have the concern of my friend, Lordship. That will be after 3 weeks, Lordship.
On the request of Mr. N. Upadhyay, learned SC Irrigation Department, made with the consent of the other side, admission hearing of this matter stands adjourned for 3 weeks.
Plus, I beg your lordship permission, my lord, to move an unlisted my writ petition, my lord. Matter pertains to my lord dismissal, and direction was given to vacate the quarter also, my lord. And
Tomorrow.
tomorrow, my lord. Obliged.
Please, I beg permission for listing of the master first validity of the select list, my lord. So it may be listed on tomorrow, my lord.
Monday.
Monday, my lord.
May I please, your lordship, my lord. I beg to mention item number 10, my lord. My lord. I am appearing on behalf of Mr. MRS M. Burman, my lord. He has some personal difficulty.
Please,
This matter-
learned counsel
After
for
1 week, my lord.
this matter stands adjourned for a week.
Item 10, after 1 week. my lord.
May I please, your lordship, I beg for a listing of an urgent matter, lordship.
Hmm.
The matter relates to suspension and the petitioner is due for superannuation on 31st of this month. Kindly tomorrow, lordship, the matter may be
Tomorrow not possible. Monday.
Monday.
Yes.
May I please, your lordship?
Much obliged.
Lordship, I beg to mention for listing of a matter for hearing, lordship. The matter was last posted on 16/10/2023, lordship.
What matter?
Lordship, the matter pertains to appointment, lordship. The appointment of the petitioner was not considered by the ONGCL, holding that the residential certificate submitted by the petitioner is only a verification report.
When do you want it?
Lordship, on 8th. Obliged, lordship.
May it please, your lordship, I'd like to beg for listing of a writ petition, my lord. It's about the select list. Some candidates have already been selected, my lord, and they will join tomorrow, my lord. We are agreed by the fact that they are not eligible. It's a lot Mondal case, my lord. Kindly tomorrow, my lord.
On 2nd of February.
2nd February.
May I please your lordship? Lordship, I beg to mention WBC 623 of 2023. The matter is related to compenssionate ground, appointment of compenssionate ground.
What do you want?
The matter may be listing on Act 2 2024.
12 to.
12, my lord, we have another case.
Then
till
16 to.
16 to. Obliged.
May I please, your lordship? Lordship, prayer for listing of WPC 512/2016.
16 to. Yes.
16 to. Lordship, can it be 12? Obliged.
Please, your lordship, I pray for listing of a contempt case, my lord. The matter was last posted on, my lord, 27/9/2023, my lord.
It will come in its own course. Contempt case, there is no urgency. You can mention.
My lord, as regard to the same, my lord, on that date, the counsel for the respondent, my lord, they stated that
You inquire with the registry why it has not been resolved.
obliged, my lord.
May I please, your lordship? Lordship, in this case, as per order of the honorable court, we have to file a affidavit, lordship. We have to file a affidavit, lordship. Petitioner was ill, so there is some delay, lordship. I will file it on tomorrow, lordship. Today maybe.
On the prayer of Mr. Ella Majumdar, I counsel for the petitioner. This matter stands adjourned for a week so as to enable him to file an additional affidavit as per the direction of this court. Yes,
Obliged.
Item 2.
I've been informed that the SLC was convened on 6/12/2023, lordship. Lordship, operative of the order dated 9/8/23, page 8, operative portion 11, lordship. Paragraph 13.
SLC was convened when?
On 6/12/2023.
So has your case been considered?
I have not been informed about this, lordship.
I heard Mr. Ardhal, counsel for the petitioner, Ferris, the order dated so and so. Alleging willful disobedience of the order dated so and so, this contempt case has been filed. Issue notice returnable in 8 weeks. Petitioner takes the service of notice upon the respondents by registered post with AD.
Obliged.
Lordship, in this case, non-compliance with the honorable court, Lordship, page 9. Lordship, order of the honorable court. And operative portion, page Lordship 10, in view of the above, and with the counsel last down below, Lordship, learned counsel for both the side, this writ petition is disposed of at his motion. No order has been passed. And the order was communicated, Lordship, that is a page 12, connected to.
So where is the statement that the representation has not been considered till today?
Lordship, Lordship, para 3, page 4.
Heard Mr. So-and-so, learned counsel for the petitioner, peruse the order dated so-and-so. In view of the statement made in para 2 of the contempt petition, this matter would require examination first step. Report alleging willful disobedience of the part to the river, second hard so-and-so. Issue notice returnable in 8 weeks. Petitioner takes steps to service of notice upon the respondent, sole respondent, registered post with AD.
All right.
My plea, the Lordship, my lord, this contempt petition has been filed inter alia praying for violation of your Lordship order at page 12, my lord. My lord, this order has been passed considering the fact that the petitioner is going to retire on 31st of this month, my lord, 31st of this month. Page 12, my lord, last 2 paragraph, my lord. Relevant, my lord.
Yes. We'll issue notice this.
Immediately on the next day, we have communicated, my lord. The petitioner is going to retire on 31st, my lord. So may I humbly submit that, my lord, if the departmental advocate is there-
No, you are completely wrong. You cannot put a gun on them in a with a contempt case and say that get me the promotion by 31st. That doesn't work. If they violate it, they will be liable to be punished.
At least they may obtain an instruction on by Monday, my lord. My humble prayer, last chance, my lord, because he is retiring on 31st. If they may obtain the instruction, what is actually happening? I am not praying for
Who may obtain?
my lord, departmental counsel, my lord, PWD. Mr. Nayak, PWD is there, my lord. If he may obtain the instruction, my lord, last chance, my lord, 31st he is retiring, my lord. A promotion, additional chief engineer or chief engineer. There was a direction by this honorable court.
That I was there, Lordship.
So by Monday, if he may obtain an instruction, my lord, I am not
Mr.
praying.
DP Bora, counsel for the petitioner, let this matter be listed again on Tuesday, by reflecting the name of Mr. P. Nayak, learned standing counsel PWD Assam in the cause list. Mr. Nayak to obtain instruction and appraise this court if any steps have been taken by the department in terms of the order dated
10/1/2024.
passed in WPC number 14/2024, and if not, the reason for not doing so.
Deeply appraised.
Copy of the.
Copy of.
Yes, my lord, I will
But
submit.
these are very, very wrong things you are doing. Very wrong thing.
My lord, my humble prayer last.
We are not going to issue any direction here.
Yes,
Let
my
me
lord,
be
yeah,
very
I am
clear.
not praying for any direction at this stage, my lord. Let him obtain instruction only.
This is not the way contempt jurisdiction is to be used.
But the petitioner doesn't have.
Yes, absolutely.
Yes.
Nobody cares for law
Yes, my lord,
nowadays.
yes, my lord, yes, my lord.
Nobody. The people who are complaining, they also don't care. The people who are being complained about, they also don't care.
Yes, my lord.
So everybody is the same.
Yes.
Yes.
Obliged, my lord.
There will be
Deeply
no direction here.
Yes,
I'm making
Lordship.
it very clear.
Lordship, I will only
Just for
obtain the
information.
instruction, what happened to
Yes,
your
yes,
Lordship.
that's all.
obliged. Yes, my lord, yes,
If
my
it
lord.
has not been done also, it's okay.
Lordship.
Yes, my lord.
We'll issue notice and see whether there is.
Yes, my lord, yes. my lord. Deeply obliged, my lord.
Relating to compensation appointment, the petitioner Lordship.
Yes, what is the instruction?
Lordship, may come to page number 41 for a moment.
Yes.
Lordship, they are saying that this is the minutes of the SLC meeting. Whereas this is not any minutes. It's just a compilation of, from the department.
Have you received instruction?
No, Your Lordship.
Then you have to obtain instruction, that is why. the matter
Lordship,
was
but
like-
there is already, they have annexed a similar order in another case. 74. Lordship, there was some mistake in our part.
You obtain instruction, then we'll issue notice.
Lordship.
We'll have to issue notice. Yes, not Mr. N. J. Govil and counsel for the petitioner. Fair will be of amendments made in the writ petition. Ms. M. Kalita, learned standing counsel, Forest Department, Assam submits that in terms of the order dated 11/1/2024, instructions as called for are yet to be received. As such, full stop given, as such, some more time is required to obtain instruction. NOM 4 weeks since Ms. Kalita has appeared and accepted notice from all the respondents, no formal notice is required to sign in this case. Extra copy of writ petition,
Last occasion was I already served them 2 copies.
copies of the writ petition. Requisite in numbers be furnished to Ms. Kalita if not already done. It is made clear then that this writ petition will be taken up for disposal at the stage of admission hearing. Parties to come prepared accordingly. Yes,
So kindly fix it, then, sir.
it's 4 weeks, 4 weeks.
Obliged, your Lordship.
Item 6.
Matter is lost. And in this case, the petitioner joined in service on
Yes.
1/1/2014.
Lordship, this is taken care by the PNRD department. All honorariums payments are,
My lord, on the last date, my lord had directed that PNRD should be included as a party. So
My lord,
we are
copy
yet
was-
to receive a copy of the writ petition, my lord, from the
Copy
petitioner.
was served, Lordship.
We haven't received it yet.
Copy was served on whom?
My lord, it was my lord, furnished to the land council for the PNRD
So
lord.
many copy.
My lord, it is received by in the my petition lordship.
Who has received it?
My lord, on the day of passing the order lordship.
Then we'll issue notice, nothing can be done.
Lordship, yes.
I heard Mr. M.H. Amin and counsel for the petitioner. There is the amendments made in the writ petition. The issue raised in this writ petition pertains to alleged discrepancy in payment of monthly remunerations to the petitioner who is serving as a Jal Mitra, within for Jal Mitra. NOM 6 weeks. Ms. M. Kalita, learned SC PhD Department, Assam, has appeared in accepted notice for respond numbers. Respond numbers 1 to 5, is it?
1, 2, 3, 4, 8, your Lordship.
1 to 4 and 8, whereas Mr. C.S. Hazarika, learned Government Advocate Assam, has appeared in accepted notice. Respond number 6. As such, service of notice upon the said respondents is deemed to be complete. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD. Taking note of the submission of the learned departmental council that the PNRD department is the nodal agency for dealing with matters of this nature. The petitioner is also granted liberty to implead the concerned authority as party respondent in this proceeding.
My lord,
My dear.
during pendency, my lord, pendency may not be barred lordship to decide, my lord. My lord, the matter is, my lord, yet to be
No, no,
decided,
that they will do it. They will not do it
my
without
lordship.
a direction.
Obliged, your Lordship.
Yes.
Well, here petitioner, my lord, is agreed by the, my lord, promotion by the respondent number 5 and 4 and 5, my lord. My lord, despite of non-qualification, my lord. They are, my lord,
We need to
unqualified,
notice at this stage, nothing more.
my lord.
You are appearing for?
I'm for the board, pollution board. In fact, this matter was subject of challenge in another writ petition which they have preferred to withdraw. And again, the same pleadings are being put forth in this petition.
You assail the maintainability. Heard Mr. S. of Planet Council for the writ petitioner. The petitioner herein is assailing the promotion
My lord,
given to the respond numbers 4 and 5 to the post of
executive environmental scientist, my lord.
executive
Environmental
environmental
scientist,
scientist,
page 110.
inter alia on the ground that they are not qualified under the rules to be promoted to the said post.
My lord.
Full stop. Mr. S. Borua, learned SC, Pollution Control Board bracket PCB, as well as Ms. M. Kalika Learned, SC Forest Department, Assam, Environment and Forest Department, Assam. Pray for some time to obtain instruction in the matter. NOM 6 weeks, since Ms. Kalita has accepted notice for respond number 1 and Mr. Borua for respond numbers 2 and 3. Service of notice is deemed to be complete in this case. And service of notice on respond numbers 1 to 3 is deemed to be complete in this case. Extra copy of the read petition, requisited numbers, be furnished to the learning departmental council. Petitioner to take steps for service of notice upon respond numbers 4 and 5 by registered post with AD. That's all.
My
They have already been promoted.
They have already been promoted.
Maintainability of the petition may
My
be
lord,
kept.
there is still.
In view of the submission made by Mr. Borua, question of maintainability of the writ petition is kept open and shall be gone into at this stage of admission here.
Public.
Lordship, in this case, the petitioners have challenged the scheme of compassionate family pension, by way of which the scheme of compassionate appointment has been done away.
What is there, on what ground you have challenged?
Lordship, basically, although the scheme was formulated and came into notification on 14/9/2017, but the cutoff date has been given as 31/3/2017, almost 6 years, 6 months before. As a result, two classes of candidates have been formed. One, those who are before 31/3/2017, those after 31/3/2017. Secondly, Your Lordship, in this case, the petitioner number 1, his mother was an employee. After his death, his father, who was unemployed, he got compassionate family pension. But after 6 months, his father also died. Now, he is not eligible under the act. He and his siblings, they are not eligible to get any kind of benefits under this scheme, Your Lordship. As mother was employed, she was getting salary. After his death, father was getting, but after 6 months, father also died. No,
So there, he is not getting compassionate family pension.
he cannot, because he has to be eligible as per Assam service pension rules. Now, under that rule, a person above 18 years is not entitled to get any compassionate family pension.
Yes, my lord, because as per this notification, my lord, he died more after that. He dated notification effect from 1/4/2017. So his ground is not tenable because my lord, he is a major person. He is not entitled to receive family
But
pension.
you
under
will
this.
not get any individual relief here. I'm making it very
Lordship.
clear. You understand the reason,
Lordship,
no?
Lordship.
Only issue that will be examined is whether withdrawal of this
Yeah.
scheme is arbitrary.
And
And the answer can be given right now.
even otherwise, Your Lordship, in a similar matter, notice has been issued.
Yes, notice issue.
Notice will be issued. Notice is issued. in
Wait, নালাগে দিব।
That discretion is no longer there now.
Lordship.
In every case, issuing a notice is the easiest thing to do.
1 and 2, 3 to কি department itu? Itu কি বস্তু?
Or Mr. M.H. Lakshman
Let
and
it
counsel
come
for
to the
the
case.
petitioner. Here is the amendments made in the writ petition. The notification dated 14/9/2017 issued by the finance establishment -A close department. What is the date of the notification?
14/9/2017. Page 57, Your Lordship.
Replacing the scheme of compassionate appointment with that of compassionate family pension is under challenge in the instant writ petition on numerous grounds. Mr. Lakshman submits that a similar writ petition being WPC number 3535 of 2023 is pending before this court, and therefore the matter be packed together. Issue notice returnable in 6 weeks. Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for this.
I am for 5 and
Appears
6.
accept notice on therefore.
5 and 6.
1 and 2.
And he is appearing for 1 and 2. Now,
Who is for 4? There is no 6 here.
6 years, my lord.
6 is there,
Yes,
but in this petition, I don't have any 6.
yes, here district level committee, 6. Deputy Commissioner.
Page
district
number 5, Your Lordship.
That is 9 again.
District level committee is respondent 5 in this case.
Yes, 5.
4, 5.
Same party, my lord. District level committee, represented by deputy, same permit.
5 is, Your Lordship, district level committee Karimganj, and 6 is district level committee.
You have to correct it,
Acha.
and correcting it means you have to file an amended cost title first. See the area of party, no notice will go.
District is defined,
One is Karimganj, one Silchar.
till sure. That's why, my lord.
No, this serial number 4, 5, he's saying there is a respondent 6.
6, yes, I am, in my case, 6, my lord.
Where is respondent 6?
Asset on that.
Who is the respondent number 6 here?
So 5 is 1, 2, 3, 4. Presentation to Milan, I am allowed. Presentation, 4 means. 34, 5, 4. 1.
Oh, Mr. Lashkar, you do your research somewhere else. You can't keep a court waiting. There's a mistake, you have to correct it then.
I'll file an amended.
Huh?
Cost item.
Then you strike it off. Heard so and so for the petitioner. Mr. T.C. Sukhia, the additional senior government advocate Assam has pointed out that there is a mistake in the error of parties which is required to be rectified before taking up the writ petition on merit. Mr. Lashkar agrees to file an amended cost title. Registry to therefore list this case once the amended cost title is filed by the petitioner.
Obliged.
Otherwise, this will remain stuck up for years together. And the registry is troubled. So you have to make your changes.
Obliged.
My lord, the petitioner was appointed as Constable UB, my lord, and she joined in her service on 12/9/1990, my lord. Thereafter,
So you obtain extradition notice.
yes, my lord, we pray for interim, my lord.
What is the interim?
Interim, my lord. My lord, they are kindly come to page, my lord. At 31, my lord, Annexure 3, my lord.
So your grievance is that your client's services have not been confirmed.
Confirm and not allowing her for the pre-promotion cadre course, my lord, to be held on 29th of January 2020.
All right. So it has not been confirmed
Yes, my lord.
for several years. Correct?
No, my lord, for this,
Since several years, it has not been confirmed.
yes, my lord.
And you want an interim order which is equivalent to allowing the prayer in the first day, let them obtain instruction.
My lord, the academy is going, the pre-promotion course to be held on 29th of January, my lord. This,
Correct, but without giving them an opportunity, no interim order can be passed.
and my lord, similarly,
If you are pressing, then the only way out is to reject it so that you can go in and.
and my lord, only on the ground of a Gorsuk PS case number 190 of
That
2017.
is your version.
Yes, my lord.
Are they not entitled to verify and we'll have it for motion then
Not.
on 29. All right. Mr. D.K. Royal and counsel for the petitioner also heard Mr. H. Chakravarti, Leonard G. Assam appearing for the state. And the request for Mr. Chakravarti, this matter is directed to be listed for motion again on 29/1/2024. So as to enable him to obtain preliminary instruction and appraise this court as to the reason why the service of the petitioner has not been confirmed till date. And also if she can be allowed to participate in the pre-promotional
Cadre course, my lord.
cadre course,
Yes, sir.
which is scheduled to commence from 29/1/2024 with justifiable, along with based on proper reasonings.
Obliged.
Obliged, my lord.
2 extra copies of the writ petition be furnished to Mr. Chakravarti during the course of the year.
Yes, sir.
Obliged.
May I please, your lordship, my lord.
Yes.
My lord, an advertisement was issued, my lord, on 27/2022 by the Deputy Commissioner Morigaon, my lord, to fill up the vacant post of.
What is the ground? You see, they advertised, your client applied, another person applied,
My lord,
that person is now out of the fray.
my lord.
Now, they don't want to go ahead with it and issue a fresh advertisement.
Yes,
You
my
want the court to issue direction, don't issue fresh advertisement, but appoint the petitioner.
lord, this is my interim plan, my lord. After my lord, lot of struggle, my lord, by virtue of
No,
RTI
but
application and
that
RTI
cannot be
appeal, my
done.
lord, I received, my lord, these.
Question
my
is
lord,
not of
documents.
struggle. Question is, they are entitled to float fresh advertisement. There's nothing wrong about it. It may not be convenient for your client,
My
but
lord,
then
they have kept this, my lord, process, my lord, pending for similar, for a long year, my lord. more than year.
show me a case law which permits this. The court cannot finally compel them to appoint you and give up the advertisement. That's not permissible.
My lord, I humbly, my lord, submitting, my lord, before your lordship, my lord, that this process needs to be, my lord, filled
Show
up.
me the law, get the order, or I will dismiss it. Howsoever humble you are, we are to administer justice as per law.
My lord,
They have invited applications, your client has applied,
my lord,
2 candidates were found in the fray,
my lord.
one of them has been disqualified. Correct?
No, not disqualified, my lord, two, in the two, my lord, post, my lord. One is, my lord, administrative officer, my lord. Two applications, my lord, were filed along with me, my lord. And in the other post of.
So can the court compel them to appoint you and not go for a re?
No, my lord, just to fill up the, my lord, post, my lord, that much, my lord, direction I need, my lord. Not to
Order
fill
is
the-
out. This kind of petitions cannot be entertained. You are not giving any answer on law.
Lord,
No.
Lordship will kindly direct the, my lord, respondent number two, that the district commissioner, my
I'm
lord, to
dismissing.
fill up the post, my lord, just to fill up the post, not to consider my case, my lord.
You show me the law which says that the court can direct them not to go ahead with the fresh advertisement.
No, I'm not, my lord, pressing regarding the, my lord, fresh
Then
advertisement.
you don't have a case.
I'm submitting before your lordship, my lord, that, my lord, the respondent number two, that is.
So
my-
your prayer is illegal, but still you want that.
No, my lord, I'm submitting before your lordship, my lord. The district commissioner may kindly be directed to fill up the post, my lord, just to lawfully, my lord, accordingly. If I'm eligible to be
Let
considered.
them go ahead with the advertisement. Why the advertisement should be interdicted by the court?
No, my lord, the advertisement has not been issued, my lord, till date, my lord. Therefore, my lord, on the basis of this advertisement, my lord, the district commissioner may fill up the post, my lord, lawfully, my lord. That much direction may kindly be, my lord.
That cannot be granted. That cannot be. The jurisdiction of the court is only when there is arbitrary and discriminatory treatment.
They may fill up the post, my lord.
Why
that much,
should
my lord.
we say that?
Because they have kept this process, my lord, pending for more than a year, my lord.
Right, so where is your right? How can you enforce your right to be appointed?
My lord, I'm not trying to enforce my right, my
Then
lord.
what
I'm
are you
just, my
doing?
lord, praying before your lordship that a direction may kindly be issued to the, my lord, district commissioner, just to fill up the post, my lord, lawfully.
Had Mr. So-and-so letter counsel for the petitioner peruse the ever mentioned the rate petition, issue notice returnable in 8 weeks.
My lord.
Petitioner to take steps for service of notice upon the respondent by registered post with AD. Hard on the prayer of interim relief, the said prayer stands rejected. Yes, next matter.
Obliged.
Not all along the services of the petitioners were taken as grade 3. While regularizing, they have been regularized as grade 4. Madam. We have.
We'll issue notice.
Well, at this stage, I'm praying for.
Senior counsel listed by Mr. So for the petitioner, peruse the amendments made in the writ petition. The grievance of the petitioners, reduced to its essence, is to the effect that although they were all along serving in grade 3 post, their services were ultimately regularized against grade 4 post, thus causing serious prejudice to the interest of the petitioners. Mr. B. Chaudhary, Leonard Standing Council, Agriculture Department, Assam, is present and prays for some time to obtain instruction and file affidavit. NOM 6 weeks since Mr. Chaudhary has appeared and accepted notice for respond numbers 1, 2,
1, 3, and 4.
1, 3, and 4.
2 will be financed.
And Mr. P. Nayak, Lanet, SC Finance Department, Assam, for respond number 2, service of notice will be complete in this case. Extra copy of the writ petition requisite in number will be furnished to the Lanet Department Council so as to enable them to obtain instruction and file affidavit. So what is this? How can you do that? If they have been working in grade 2, how you can downgrade them?
In fact, my lord, there is, we have annexed the judgment.
Lordship, that judgment they are contemplating for appeal, and with regard to this petition, Lordship, I have to go through the records.
No, appeal or no appeal, we'll see. That
Yes,
is
ma'am.
another matter. But there is something called things which are legitimate, which are in accordance with law. That you cannot shy away, no? So if people are working in a grade 3 post, regularization means what? You have to regularize their service in the post in which they are serving.
Lordship, I have to take the background of the petitioner service. Background of the petitioner service, because initial appointment was what nature? That only the records will reveal, Lordship.
All right, you file your affidavit.
Yes.
Let them file, yes.
May I please, Lordship? My lord, matter pertains to appointment on compassionate ground, my lord.
Yes, what is the instruction?
I have not received any instruction, Lordship. Some time may be given to take instruction.
You issue notice.
Lordship.
But Mr. A.H. Ramar Chaudhary and counsel for the petitioner peruse the amendments made in the writ petition. The petitioner is aggrieved due to delay in consideration of her application for appointment on compassionate ground. Mr. Chaudhary submits that there is no valid reason for delaying the process, thus causing serious prejudice to the interest of the petitioner. Full stop. Ms. R. Devi, Lanet CGC, Appearing for the respondent numbers,
All the rest.
appearing for all the respondents, please for some time to obtain instruction demand. NOM 6 weeks since Ms. R. Devi has accepted notice for all the respondents, no formal notice, extra copy. It is made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law if they advised.
Obliged.
Please, Your Lordship. Lordship, in spite of the petitioner being selected, he was not appointed. In fact, this is the second round of litigation. Previously, there was a direction from this honorable court to pass a speaking order. However, after the representation, nothing is done and the matter is still kept pending. No appointment order is passed.
Where is your name in the select list?
The Lordship will find it in the page number 17, annexure 1 is the select list. And at page 18 is the relevant portion. The second is selection, serial number 1, Jyoti Das.
This is dated?
This is dated 2019, Your Lordship.
The 2019 select list is valid even now.
Lordship, I filed a writ petition, Your Lordship, as nothing was done. And there was a direction by this honorable court to, Lordship, the order is in page
The writ
38.
petition you filed in 2022.
Yes, Your Lordship.
How long is the select list valid?
The post is still vacant, Your Lordship. Nothing has
No,
been done.
the question is how long is the select list valid? You answer something, the court asks you something, because you know the answer is against you.
Lordship.
But that's not how you will get an order from this court.
Understand.
Just because this question was not asked earlier doesn't mean the court will not ask you now. A select list is valid for 1 year.
1 year.
Unless it is extended. So today, how this select list can be given effect to? Satisfy the court, get an order.
Lordship, there were representation as regards something has been done for extension or not. Nothing has been responded to that as well. There were representations.
You find out if the select list has been extended or not. If it has not been extended, we'll close it. Nothing can be done. You have to be vigilant. This lackadaisical approach is creating a tremendous problem for the system. It's time to tighten up things. Have you stated that this select list is still valid?
I have stated the post is still vacant, but I have not.
Yeah, it will
mentioned.
remain vacant for next 5 years, so. But your right springs out of the select list.
Yes, sir.
Why haven't you come earlier?
Because there were communications, representations, but nothing was done. Your Lordship. Finally, in 2020.
Writ of mandamus cannot be issued. Writ of mandamus cannot be issued unless
The select list is
it
still
is, yes, that's the
extended.
law. And the courts will have to follow the law. That's the problem. The courts are the only institutions
governed by law.
which are completely tied down by law. So give an answer to the query and then get an order. There is no difficulty. The court is not against your client.
I understand.
But we have to go as per the law. Otherwise, this will lie for 2 years and then there will be a contempt and then there will be a resistance and then there will be an appeal. All this we cannot allow. This is all happening because of these reasons. The initial orders are passed without verifying or ascertaining few things. And these things surface much later after 2 years, 3 years.
Lordship will also consider the disregard by the officials, Your Lordship. There was
Disregard
an
by?
order, there were representations, there were no communications on their part.
Which is the order of the court?
The order of the court is at page 38, annexure 8. The last paragraph at page 40 is the specific direction.
This is only to dispose of representation. But as I have pointed out, this kind of omnibus orders makes you happy, nobody else. Because the court has not, if the select list is not valid, how they have to consider the representation?
There had to be a response that the select list is not valid, Your Lordship, but
All right, we'll find out how Mr. Vijay Mukherjee and counsel for the petitioner peruse the amendments made in the writ petition. The petitioner is seeking a writ of mandamus for enforcing her right of appointment based on the select list dated, what is the date of the 25 to 2019?
25.
However, there is no amendment in the writ petition indicating as to whether the select list is still valid at this point of time. As such, this matter would call for examination, issue notice returnable in 4 weeks. Mr. C.S. Hazarika, learned G.A. appearing for the state, accepts notice on behalf of all the respondents. As such, no formal notice, extra copies. On the next date fixed, the learned G.A. obtain instruction and appraise this court. If the validity of the select list dated 25 to 2019 had been extended beyond the period of 1 year. And if so, the order by means of which the same was done. Let them show it. If the select list is found valid, then you have a case. Then you have a case.
Lordship, if the instruction is holistic regarding the other amendments as well, that will be more helpful for.
Sorry?
If the instruction that is directed to be brought is.
No, if the select list is not valid, then regardless of whatever it is, no mandamus can be issued. The reason I'll tell you, which it may not have occurred to you ever. The writ of mandamus is available to the courts to compel the departmental or government or executive machinery to discharge their constitutional legal duties. Right, nothing else. First, you have to show that they had a duty to do a particular thing in a particular manner. But they have not done it. Only then writ will be passed.
Even
unfortunately, this code follows this principle.
Understood.
You can either argue that that principle is not correct,
I
something
understand
else
it.
is there, or I will follow this. There is no other way out.
I understand, Your Lordship, but
Yes,
why I am praying for an holistic instruction, Your Lordship?
What will you do with the holistic instruction?
Because-
Supposing he says that it has been illegally denied to her, but the select list is not valid. The writ petition has to be dismissed.
Lordship, even if it is illegally denied to or whatever, Lordship, even he had a legal duty to dispose of my representation,
Why didn't you come to court in the right time?
dispose of the representation as directed by this honorable
Dispose
court.
it off, dismiss it, reject it. But this is mounting, these
understand, Your Lordship,
these
but-
are of no use.
I
This is
understand, Your Lordship.
just bombarding the departmental officials with additional work.
But Your Lordship,
I'm sorry to say this. There has to be a finding that if the claim of the petitioner is correct, then he or she will be entitled to this relief. Then the court can say that now you consider the representation. Somebody asks for the moon and the court says, consider it.
Either
What will the official
consider
do?
or either reject, Your Lordship. There has to be some regard to the order of the
All
court.
right.
I am on that only, Your Lordship.
I'm sorry to say, this court does not subscribe to that view. Yes, there are cases where it is not a foolproof case, but the fundamental principle must be in favor of the petitioner. Fundamental principle should be there. Fundamentally, if the matter is out of the legal regime, insofar as the established principles are concerned, then issuing a mandamus will create a problem for the department. They will find it difficult to implement it. This is why we see so many contempt cases. Today, thousands of contempt cases are being filed. I don't want to say anything more than that. Yes.
Item 15.
Lordship, petitioner is at present working as a habilder in Assam Police Battalion. Lordship, all the habildars of the same rank has been sent for promotion. Name has been sent for promotion to the committee for selection. Petitioner has been left out, Lordship, and petitioner has not been given the financial increments. So petitioner has been given seniority with effect from junior has been promoted. I ordered, Lordship will find the order at page 22. Page 22 is the order by which petitioner has been given seniority from the date of junior has been promoted. Page 23 is the given portion. After passing the above cadre course, his seniority will be fixed as follows: as Lance Naik with effect from Iman, and Habildar with effect from Habildar, Iman, at a cadre course and promoted to the rank of Habildar, height paid Iman. Earlier, petitioner has completed the course and petitioner has been promoted. Page 24. Page 24 is the promotional order.
All right. Why he has been denied promotion? And
No. Now, Lordship, all the habildars' name has been sent to the selection committee for promotion. My name has not been sent. And I have not given the financial benefit from the date of my juniors has been promoted.
So that's what we are asking you. You said no. Right?
No promotion, Lordship. Consider for promotion.
That's right.
I'll have to obtain instruction.
What to do? Notice or motion?
No, Lordship, let notice go because otherwise this is, in this case, there was another previous litigation where the almost, he's himself saying in the petition, almost all the benefits have been given, some 1 or 2 benefits, including this promotional benefits and all are left,
no.
but otherwise all other consequences benefits have been given. That's what he has been saying. Some benefits have left. So let notice go, will file our.
Now,
affidavit.
only thing is, Lordship, and at this stage, I pray, Lordship, let my case should be sent to the committee for selection if I'm eligible.
On 2nd February, obtained instruction, how Mr. S.K. Goswami and counsel for the petitioner, there is the amendments made in the writ petition. The grievance of the petitioner is that although he is entitled, eligible
To consider.
for being considered for promotion to the rank of
APB, ABSI, Assam Police Battalion SI.
ABSI, yet his name has neither been sent to the DPC for consideration, nor has the petitioner been extended the benefit of enhanced pay in lieu of career progression. Mr. Goswami further submits that the process for sending the name of eligible candidates for consideration for promotion is under progress at this stage, and therefore an interim order be passed by the court in favor of the petitioner. Mr. C.S. Hazarika, Leonard G. Assam, 6 time till 5th of February 2020. 24 to obtain preliminary instruction responding to the submission of the petitioner's counsel. Prayer allowed, list this case again on 5/2/2024 for motion as a fixed item. 1 extra copy each be furnished to Mr. C.S. Hazarika and Ms. Yarfo.
And for respondent, 4.
Who is respondent for?
AGM.
Then you don't have anything to do now. 2 extra copies of the petition be furnished to Mr. C.S. Hazarika and G. Assam, appearing for respondent numbers 1, 2, and 3. Stop. Ms.
S. Barik.
S. Bari, Lyric Council is present for respondent number 4.
Public.
You tell us what is the reason, otherwise we'll have to protect his interest. Yes.
Item 16.
Yes, Mr. Patel.
My lord, Annexer 2, my lord, page 21. This petitioner, my lord, reported some matrimonial disputes involving another person to the commandant. Unfortunately, my lord, without knowing the procedure, he gave a copy to the DGAR also, which is violating the chain of correspondence. Thereafter, my lord, there was an inquiry also on the matter, in which, my lord, he had apologized and sought to withdraw the letters, and the respondent said that, the commandant said that, okay, will be permitted to withdraw the same in due procedure. 1 year thereafter, my lord, in December this year, my lord, last year, he is given a charge sheet that I have violated the chain of correspondence, and therefore a charge sheet has come, my lord. I'm against that, my lord.
But at this stage, how can the read court interfere with this?
My lord, I understand.
You have violated the chain of-
Admittedly, yes. Admittedly, my lord, I had admitted.
If they impose a penalty which is disproportionate or the charges are held to be proved illegally, then we can interfere.
My lord,
But at this stage, how can it be? You have violated.
my lord,
It could have been ignored. But they did
Would have
not
been
ignore it. Then
ought to have been included, my lord, rather, in the circumstances, my lord, in the circumstances.
they chose not to. So now we will be sitting in appeal over. They are not doing anything which is illegal or in violation of the
My lord,
rights.
I understand,
That is what I keep mentioning again and again.
my lord.
The councils are expected to take the case to that level where the courts can come to the aid of the, that
Normally,
is not happening.
normally, my lord, charge sheet is not to be interfered with because no right is, I understand, violated. But in cases where circumstances demand, my lord, that totally unjustified if a charge sheet is issued, my lord.
Circumstances demand that if a court has to give a judgment, it will say that there is nothing wrong. That will be devastating for your client. It's true, you are right.
Hello.
But that's how this these people, handle things, what to do.
My
They
lord.
may have their own reasons. We may have our own, realities.
The other
Stepping on the
connected
judicial
reason, my
side, for
The connected reason also I have cited, my lord, is actually the wife had also filed a maintenance claim, which I said that let the appropriate court in which the maintenance case is pending, let it be decided.
But that has
So
nothing
before
to-
that, it should not be deducted. Probably that reply actually has resulted in this particular charge sheet,
At
my
this
lord.
stage, we cannot.
Those
write a
records I have
judgment.
also produced, my lord,
There is no judge, this court cannot write a judgment in this case.
my lord.
The only judgment would be that they are justified, which will be bad for your client. I don't think you should have approached the court. Give your reply and see how they deal with it.
My lord.
You are agreed and the final.
Actually, they did not give any time for reply also as such. There's nothing fixed as such.
14 December, by this time maybe reply has already been filed, Lordship.
He only took an interview of the person. He said he was called by the commandant. Put the query only, no procedure has been done as such. But then the maintenance is the issue probably that is basically.
That we're not concerned, whether it's maintenance or lack of maintenance, that's not the point here.
My lord.
Point is, did you have any ground to approach the writ court alleging violation of your right? Obviously no.
No, very narrow compass, my lord, I understand.
So
Very
there are
narrow.
two options, either the writ petition is dismissed with the reasoned order or you withdraw it with liberty. What else can be done here?
But the second part that I had assailed is the maintenance part also, that part. Maintenance, I said that, my lord, is to be paid, and in the Assam Rifles Act, there is a provision which says that if a maintenance petition is filed before the authority can deduct a percentage of the salary and pay it directly. I had said that, my lord, there are a number of decisions in which it has been said that the appropriate court, if a proceeding is pending, let the appropriate court decide, and thereafter, since my salary otherwise cannot be attached in execution under the Assam Rifles Act, this particular provision is there so that the maintenance is paid. So that seems to be actually the background behind its charge sheet.
You want to pursue it?
My lord.
Yes,
Mm.
okay.
Okay.
We'll issue notice,
My lord.
but stay order will be rejected. Interim relief will be rejected.
My lord.
Heard Mr. B. Pathak, learned counsel appearing for the petitioner. Here is the averments made in the writ petition. The petitioner has approached this court internally assigning the tentative charge sheet dated 14/12/2023 by contending that there was no valid ground for the respondents to proceed against the petitioner in the facts and circumstances of the case. Full stop. Responding to the above, Mr. R.K.D. Chaudhary, learned DSGY submits that this is a clear case where the line of authority has been violated, and therefore, since it constitutes a misconduct under the rules, the respondents were justified in furnishing the charge sheet dated 14/12/2023. Full stop. Unless the petitioner submits his reply, public response to the charge sheet, there is no ground for the writ court to interfere in the matter. After hearing the submissions of learned counsel for the parties, this court finds substance in the submission of the learned DSGI. However, since an ancillary issue in the form of
Maintenance to the wife. Maintenance to the wife.
Scope of deduction of amount from the salary of the petitioner as maintenance to the wife is also raised in this writ petition. The matter would call for deeper examination. Full stop. As such, issue notice of motion returnable in 8 weeks. Since Mr. R.K.D. Chaudhary, learned DSGI has appeared in accepted notice for respondent numbers 1, 2, 3, and 4. Service of notice on the said respondents is deemed to be complete in this case. Extra copy of the writ petition requisite in numbers be furnished to the learned department counsel. Petitioner takes 5 is the wife. This
5 is the wife.
Petitioner takes steps for service of notice upon respect 5 by registered for. Do it within a week.
Hello.
And you want to also serve by Dusty? No, that's not.
See, settings staying outside.
Hard on the prayer of entry, the said prayer will be considered on the returnable date. Pendency of the writ petition shall not be a bar for the authorities proceeding the matter. in accordance with.
For admission, item 17.
May I plead, Lordship?
Yes.
Lordship, my only prayer is that if Lordship may kindly come to page number 30.
Where is Mr. Pine?
Is on lakhs in court number 3.
Let him come.
Lordship.
Today he has not come.
He has come, he is in court number 3.
Acha. So you want to argue the matter?
As instructed by Mr. Pine, he has told that on page number 30, it is given para number 7. The petitioner may be considered in this case, according to this condition, my lord. 30. Advertisement. I see. Yes.
Who, the private respondent has scored higher marks than the petitioner. And which is the statement in your affidavit? Which paragraph?
Paragraph number at page number 2, paragraph number 3, that next paragraph, it has not been numbered, Your Lordship. But next page, Your Lordship, page number 3, after completion of the interview, at the beginning of page number 3, internal page number 3. After completion of interview, as per government guideline, it was observed that percentage of marks in higher secondary examination of all the 3 candidates are as follows. Rumi Pegu, 40%, that is a private respondent. Position number 1, Bornali Mini, 32.8. Jibon Mili Paga, 32.6. Third, that is a petition. As Srimati Jibon Mili Paga belong to disabled category, so then selection committee unanimously decided to select Srimati Jibon Mili Paga under disabled category for the post of Anganwadi worker at Balikoi Boa Balizakoi Boa Anganwadi Center and prepared the comparative statement of merit list and final select list along with the minutes of meeting and placed to the director for necessary approval. And Director of Social Welfare approved the final list of Anganwadi worker and Anganwadi helper under Majuli ICDS project except for Balikoja Boa Anganwadi Center. By Directorate letter so and so, the selection of Anganwadi worker was held up by Director of Social Welfare and clearly stated that the selection of disabled candidates against 3 numbers of Anganwadi worker posts is not as per government norms and guidelines. The director also instructed CDPO to place the matter of selection of Anganwadi worker Balikojo Boa Anganwadi Center before selection committee as per government norms. After receiving the director approval letter as mentioned above, published the result of interview except Balikojo Boa Anganwadi Center. On 22/7/2021, CDPO Majuli ICDS project placed the matter of selection of Anganwadi worker under Balikojo Boa Anganwadi Center with all relevant documents before selection committee and informed the committee that directorate had held up the selection of Anganwadi worker at Balikojo Boa Anganwadi Center. CDPO also informed the committee that selection committee selected Srimati Jiban Mili Pogak on the basis of disabled category. Although there was no reservation for disabled category against 3 numbers of vacant Anganwadi posts, worker posts as per government guidelines dated 25/1/2019. Para 2, subpara 3. It is clearly mentioned in the guideline that 3% posts shall be reserved for differently able candidates. Then CDPO also informed the committee that merit position of all the 3 candidates as per government guidelines are as follows. So after that, then CDPO also informed the committee that selection is to be made completely on a merit basis and there are no individual marks in the interview as per government guideline. Now, on last occasion, Lordship, I placed the relevant materials, and Lordship, I'll just point out those particular. I flag marked the relevant pages, Your Lordship, here in this regard. First, Your Lordship, I'd like to take Your Lordship to the notification dated 25/1/2019, which I flag mark as 1. And Your Lordship may kindly go to subpara 3, wherein the particular reservation for disabled candidates is made. Then I'll like to take Your Lordship to the flag mark number 2. That is the letter dated 22/7/2021, placing details before the selection committee with all the marks. As my learned friend was actually stressing on that particular clause number 7 of the advertisement, that only says preference will be given, but the main criteria herein is the HSLC and HS marks. As per the guidelines. If I would like to take Your Lordship to flag number 2, Your Lordship. Yes, the letter dated 22/7/2021, placing details before the selection committee. And then Your Lordship may kindly go to flag number 3. That is the selection committee minutes. Somewhat the photo set is not clear. I'm sorry for that, Your Lordship.
So there were 3 candidates interviewed,
3 candidates.
out of which the petitioner was third in
Third.
order of merit.
Yes.
But the selection committee had recommended her as a candidate with disability.
Yes.
But there was no reservation
There was no
because
reservation.
there were only 3 posts, 3 vacancies.
Only one post of, in this particular post, there was only one post. Balikojua Anganwadi Center, advertisement at page, in my rate petition copy is page number 26, but I'm not sure in Your Lordship's copy, which number page, because pagination is somewhat not proper.
The advertisement is on page number.
Page number 29.
In my
29.
rate petition is page number 26, so there is somewhat. Other posts are all Anganwadi helpers, Your Lordship.
And so they say that the respondent number 5 never applied for the post of Anganwadi worker.
Yes, coming to that also, Your Lordship, on last occasion, my learned friend actually, Mr. Payeng, he pointed out that the private respondent had applied for the post of Anganwadi helper, and they had annexed that particular application form also. In that particular, in the photocopy also, there is at flag number 5.
Yes.
First, just prior to the flag number 5 is the original, is the copy of the earlier submitted application. Of course, it was mentioned as Anganwadi helper, but on the same day at 3:30 PM, she filed a application and it was received at 3:30 PM. That I had made a mistake. So that because the whole advertisement is for Anganwadi worker and I have mistakenly had applied for Anganwadi helper. So kindly consider me. So that was considered, and that's why she was considered for the post of Anganwadi helper, worker.
And you have stated it in your
Affidavit also.
Where is it? Which paragraph?
At second page itself, Your Lordship. That unnumbered paragraph, that with regards to statements made in so and so. The deponent states that an advertisement was published for 3 Anganwadi workers posts, including Balajakova Anganwadi Center under Majuli ICDS project. There were three number of candidates for the post of Anganwadi worker at Balikojua Anganwadi Center. On 30/10/2020 morning, Srimati Rumi Pegu submitted her application to the Office of the Child Development Project Officer, Majuli ICDS project, indicating the post applied for as Anganwadi helper at Balikojua Anganwadi Center. On 30/10/2020, that is on the same day, at 3:30 p.m., Srimati Rumi Pegu submitted another petition addressed to the CDPO with clarification and prayer to allow her to appear at the interview for the post of Anganwadi worker at Balikojua Anganwadi Center against the vacant post of Anganwadi worker. Srimati Rumi Pegu also expressed unwanted mistake for the same. Then selection committee allowed all the three candidates to appear in the interview for the post of Anganwadi worker at Balikojua Anganwadi Center. Accordingly, interview was conducted on 12/11/2020. There was one candidate, Srimati Jivan Mili Paga, who belonged to disabled category. So you have stated that.
So private respondent is presently working.
He is present.
So you said there were three posts of Anganwadi worker. Which are the three posts? Come to page 27 of the writ petition. It shows only one Bali Zokai Boa Anganwadi worker. Which are the others?
That is what I am also, in fact,
Three posts or three candidates?
three candidates actually. Should have
Why have you
three
mentioned three posts?
somewhat maybe a typographical error here in your lordship, because otherwise the advertisement says only one post of Anganwadi helper worker. Balik Ko Jokai Goa. Bali Jokai Goa.
Yes.
Lordship, my only prayer is that she may be considered in this condition only, according to point number 7. If that are not possible, then Lordship may.
According to point number?
Point number 7.
Which point?
Advertisement, Annexure 11. He has the qualification.
No, preference will be given. If they have equal marks, then preference will be given. That position has been now settled, is it not? Preference doesn't mean bring the lower candidate up. That doesn't mean that. Preference means if two candidates are of equal merit, then one is to be preferred. That doesn't mean a candidate with lesser merit will be preferred over a higher merit. That is not the meaning. So, let me dictate the order. Your name, please?
A Payang.
Heard Ms. A. Payang, learned counsel appearing for the writ petitioner. Also heard Mr. D. Bora, learned government advocate Assam appearing for the official respondents. None is appeared for the respondent number 6. The controversy raised in this writ petition pertains to the selection and appointment of respondent number 6 in the post of Anganwadi worker, Bali Zokai Boa, age 27 of the engagement. Bali Zokai Boa, Anganwadi Center in the district of Majuli. The facts of the case, in a nutshell, are that on 16/10/2020, the Child Development Project Officer Majuli, that is the respondent number 5 hearing, had issued an office circular inviting applications for filling up of one post of Anganwadi worker in the Bali Zokai Boa Anganwadi Center and 6 posts of Anganwadi helpers in 6 other Anganwadi centers mentioned in the circular, which are not relevant for the purpose of this case. The petitioner herein was amongst the 3 applicants for the post of Anganwadi worker of Bali Zokai Boa. After the selection process was concluded, results published by the authorities went to show that the respondent number 6 hearing had secured the highest marks of secured the first position by obtaining 40 marks, whereas the petitioner herein emerged in the third position with 32.6 marks. Another candidate, namely Srimati Bornali Mili, Bornali Mili, secured 32.8 marks and stood second in the selection process. Since the petitioner was a candidate belonging to the category of persons with disability (PWD), the selection committee had initially recommended the name of the petitioner for appointment in the post of Anganwadi helper in deference to clause 7 of the circular dated 16/10/2020, which provided that preference was to be given to female candidates having certificates of dance, music, sports, medicals. However, on assessment of the materials on record, the Director of Social Welfare had pointed out that since there was only one post of Anganwadi helper, hence the question of reserving 3% of the post for being filled up by PWD candidate did not arise. As a matter of fact, there was no mention of any reservation of posts in this circular dated 16/10/2020 for any category, including persons with, including the PWD category. Taking note of the said aspect of the matter, the selection committee reconsidered the case and ultimately decided to recommend the name of respondent number 6 for appointment as Anganwadi worker. Consequently, the respondent number 6 was appointed as Anganwadi worker in the Bali so Anganwadi Center, and she is continuing to serve in the said post till today. The petitioner has assailed the selection and appointment of the respondent number 6 primarily on two grounds. Firstly, that the petitioner had the respondent number 6 had applied for the post of Anganwadi helper of Bali Kazwa also, but she was appointed as Anganwadi worker without there being any application made by her to that effect. Secondly, the petitioner being a candidate belonging to the PWD category, preference ought to have been given to her, in which event she would have been appointed in place of the respondent number 6. And so far as the first round is concerned, I find from the counter affidavit filed by the respondent number 5 herein that although the respondent number 6 had initially applied for the post of Anganwadi helper, yet Anganwadi helper on 30/10/2020, yet at around, realizing her mistake at around 3:30 p.m., the respondent number 6 had submitted another petition addressed to the respondent number 5, clarifying that she was an applicant for the post of Anganwadi worker at Bali Jakoibua Anganwadi Center. Full stop. It is to be noted herein that the post of Anganwadi worker was only advertised in respect of Bali Jakoibua Anganwadi Center. Full stop. The aforesaid statement made by the respondent number 5 in the counter affidavit in paragraph 4 has not been controverted by the petitioner by filing any rejoinder. If that be so, it cannot be said that the respondent number 6 had not applied for the post of Anganwadi worker in the so-and-so Anganwadi center. Full stop. Secondly, although clause 7 of the circular dated so-and-so mentioned that preference is to be given to candidates of certain categories, including those having certificate of medicals, and those having medical certificate. Yet the same did not clearly mention the criteria to be followed while giving such preference. Stop. There is no doubt or dispute about the fact that the advertisement notice, that is the circular dated 16/10/2020, did not mention of any reservation of post for the category of PWD candidates. That be so, it is apparent that the selection for the post, that be so, ma'am, which is understandable in view of the fact that there was only one post of Anganwadi worker of Bali Dokaibua Anganwadi Center, which was advertised. Law is well settled that there cannot be reservation of any kind in case of a single vacancy. Therefore, the question of reserving the seat post for persons with PWD also did not, for persons with, for PWD category candidates also did not arise in the eye of law. First of, moreover, law is well settled that preference in matters of employment can be given only when two candidates are found to be of equal merit, and such criteria for giving preference is clearly spelled out in the advertisement notice. First of, in the present case, as has been noted above, petitioner stood third in order of merit, but the respondents have appointed the respondent number 6, who stood first in order of merit. First of, therefore, the question of giving preference to the writ petitioner over the respondent number 6, even under clause 7 of the circular dated 16/10/2020, would not arise in the eye of law. For the reasons stated herein above, this court is of the opinion that there is no merit in this writ petition. The same is accordingly dismissed. Records produced by the Learned Departmental Council is hereby be returned. Yes.
Item 18.
Yes.
Yes, my lord. We have challenged the entire appointment procedure. My lord. The
Yes, what is
My
it?
lord. My lord, there had been an advertisement for appointment of two assistants, in the office of the respondent, that is the District Industries Commerce Center, Golaghat. The notice was published by annexure number 2.
This is what selection process of 2015.
15, my lord.
You are challenging the selection and appointment to respond numbers 4 and 5.
My lord.
But have you lodged any FR?
No, if I might. No, if I, actually, what happened, my lord, that I have participated in the proceeding. I was thinking that everything is going well, everything is within here. Thereafter, I sensed that there was some irregularities, illegalities, not irregularities, but illegalities, my lord. Even the question paper was collected from father of the one of the candidate. He has collected not question paper along with answer sheets.
No, that's all right, but
So-
these are your allegations.
No, these are on record.
See, Mr. Sharma, we have to come to the point quickly,
My
okay?
lord.
Otherwise, 2 cases a day.
My lord.
Choice is for the bar to decide. You are alleging fraud,
My lord.
but no, fraud is a criminal offense. There is no
My lord.
other lodge. The REIT court cannot investigate fraud. Correct? Listen, yes or no? you tell.
My lord.
So are you giving up on your allegation of fraud? If you give up, then the writ petition will have to be dismissed.
I
If
am,
you pursue it, we'll hear it in due course, because this court can never record a finding on whether what you're saying is correct or not. These are all to be done on the basis of investigation by an agency, and the facts will have to be brought in record. Merely because you have alleged, how the writ court find out who has collected the question paper?
that is on record.
Hmm?
That is on record.
We'll
That is
admit
on
it and
record.
hear it in due
My
course.
principal, the question paper setter had given reply that such and such person has collected the question answer sheet.
Right.
Firstly, the respondent, respondent number 3 says that the manager, the district manager had collected answer sheet. Firstly, here they are suppressing the fact. They have informed us that I have collected the question sheet. Then, when we inquired the matter from the principal of the college, who is the question setter, he said the Ballabh Jyoti Bore, father of the one of the
So there are
has collected.
disputed
Thereafter,
questions.
even this, thereafter, they have replied that yes, he has collected the question sheet. They have also replied.
We'll
So
hear
it
it
is
in
on
due
record.
course.
So there are two persons, actually, Lord, say 2 officers have been entrusted. So this is not only the father, the 2 officers have been entrusted to collect the question papers from the principal of a college. That is the thing. That is the only
The
presumption. that-
problem is you should have lodged an FIR. The
Yes.
police and the CID would have gone into it and see.
My lord,
Otherwise, how will you expect
lord-
the judge to decide all this?
my lord, in fraud matter, that will be a civil matter as well as criminal matter also.
Hear it,
That is fair.
not an admission.
Fraud may be civil matter as well as criminal matter
No,
also.
no, civil fraud is, you have to have evidence, Mr.
My lord.
Sharma.
It is on record.
See,
Let them deny.
the
They cannot deny. They have not denied
only
it.
record permissible for the court is to dismiss your petition.
My lord, they
I
have,
can do it today.
my lord.
Because these are, you allege, they will deny it. A matter ends there.
They have not denied it.
You have admitted, you are appearing for
They have
whom?
not denied it. That, but.
You admitted fraud.
Yes, no, admitted fraud is not there, but they have admitted, they have not denied that Mr. Bori has collected question paper. They have not denied it.
Hmm.
They have not denied this fact. They have not denied this fact. On the report, they have not denied this fact, my lord. That is the matter.
We'll admit it and post it for
Yes.
hearing. Pardon, Mr. Sharma, but I'm pointing it out to you.
My lord.
The writ court cannot record a categorical finding on this. These are
No,
matters.
there are other anomalies also that I can point out without, there are other anomalies.
Petitioner, taking the awareness made in the writ petition. After hearing the submission of the petitioner's counsel, this court is of the opinion that the writ petition deserves a full length hearing. Mr. A. Kalita, Learned Standing Counsel Industries Department is present on behalf of official.
Respondent number 4.
And you are for?
I'm from the Industries Department. Lords.
Which respondents?
Private respondent, yes, Lords, 1 to 3, Lords.
1 to
1 to 3.
Mr. M. Sharma for respondent number 4. Miss Deepa Pujari, Learned Counsel for respondent number 5 are present. Since this matter is ready as regards, pleadings are also ready.
Well, already,
So we'll have it in 3rd week of April for final hearing.
my lord.
Lords,
Since this matter is ready as regards some pleadings, on the request of Learned Counsel for the writ petitioner, let this matter be posted for final hearing on a non-miscellaneous day in the 4th week of April 2024 as a fixed item.
My lord.
But you please check this, there are recent judgments on this.
Sure.
If there are elements of fraud and you have not lodged an FIR, that will go against the petitioner.
Madam.
In this case, Mr. Deenat was supposed to address the court today. He has to, but one of his relatives has been hospitalized, Your Lordship. So a short accommodation, I'm praying for, Your Lordship.
The petitioner's counsel is present.
Monday, Lordship, kindly fix.
Huh?
Fix on Monday, Lordship.
What is this matter about?
Another promotion matter, Lordship.
Huh?
Onconbody worker to promote supervisor, Lordship.
The learned government advocate Assam submits that Mr. D. Nath and his senior government advocate Assam, who is handling the brief, has not been able to come to court today due to a medical emergency at his home. And therefore, this matter be passed over for a week. Prayer allowed. Let this case be listed again after a week as a fixed.
Lordship, just one thing.
After a
Kindly fix, Lordship.
He may come, Your Lordship, but he's saying that better to pray because otherwise he is not. It is not certain whether tomorrow, if I make a suggestion that he's not coming and then he can't, it may look on that side.
20. May please, Lordship, matter may be adjourned for the day as planned.
prayer of petitioner's counsel, this matter stands adjourned for 2 weeks.
Much obliged.
That's matter is relating to my lord appointment on compassionate ground, my lord. The case of the petitioner was considered and rejected by the appointment order, lordship will find page 33 on the ground of on financial ground, man. Page 33, they have mentioned that last parameter, lordship will find the case of the petitioner could not be considered on financial ground because they have said that, my lord, after the death of the father, he has received pensionary benefit and gratuity and other retirement benefit money. And it is, my lord, in the affidavit, you will find, they have stated that huge amount, nothing has been mentioned, but in my reply, I have annexed all my amounts what I have received. I am getting only pension of rupees 14,000 now.
You are whom? You are the father? Yeah, son?
Son. My mother is receiving pension, my lord. She is receiving pension, my lord, only 11,000. Now it is 14,000. 14,536. And retirement benefit was received, my lord, 11,3,800, my lord. And there is also a huge loan amount, my lord.
Where is the order rejecting?
Order page, in my petition, page 33. The last parameter is relevant.
So there is a scheme of compassionate appointment framed by the APDCL, right? Right?
Yes, Lordship.
Does it permit this kind of a consideration?
Lordship, the financial position of the family is to be considered, Lordship.
It is mentioned in the scheme.
Yes, Lordship.
Where is the scheme? Is it on record? Mr. Nath, is the scheme on record?
Lordship will find. Yes, my lord. Lordship will find page 24A, my lord. 24A, Annex 6 of merit petition, my lord.
Page 24A. And which is the relevant clause which permits financial?
Lordship, it is eligible. The family is in the indent and deserve immediate assistance of the relief of the financial decision.
Which page, please?
Yes, Lordship, it is
Clause
Annex,
6,
Annex 6, Lordship.
Page 24A, my lord. Yeah, clause 6, my lord. Eligibility.
Yes,
Right?
eligibility, yes.
Oh, 24, 24 is, office number, 24, yes. Well, there is nothing clear regarding my specific eligibility and financial slab or nothing, my lord. Only
So when was the application submitted for compassionate appointment?
within 10, my lord, in 14, my lord. He expired, my lord, applied on 38/2014. And petitioner further expired, my lord, on 8/7/14. And they have, my lord.
Mr. Goswami, what do you have to say? How can it be done like this?
Lordship, page 38 in my affidavit, Lordship, wherein it is stated, Lordship, that immediately after the date of the deceased, Lordship, the family got 21 lakhs 20,634 rupees, Lordship. Received the amount, Lordship, as well as, Lordship, they withdraw the salary of they withdraw the pensionary benefit of 21,586 for per month, Lordship, and therefore it is considered that the authority considered that sufficient means of financial.
So compassionate appointment is made to help the family tide over immediate crisis.
Yes, Lordship.
Sole breadwinner is lost. It is not a matter of right. It is a gesture from the authorities.
Yes, but it is delayed only due to their fault, my lord. They have considered only in 2000 illogible fine. Order was passed in 21, my lord. 2020.
Is there any decided case law on something like this, similar matter, where pension and gratuity, etc. is paid, so compassionate appointment denied? Any case decided?
I have to go through it, Lordship.
Are you aware?
My lord, no specific, but there is a decision of my lord today that I am having 1994 4 SCC. Umesh Kumar Nagpal case is there, my lord, Supreme Court. But it is said that only at the time of immediate consideration, that financial hardship is there or not, that is to be considered. No specific criteria is given. I will please, your lordship,
No, now today there is no hardship. Why should he be?
Yes, my lord, because of the fact that, my lord, 11 lakh, there is a loan, my lord, I have annexed it. The loan of house loan was 11 lakh something. That has been made out of the retirement benefit amount, my lord. And one daughter, my lord, going daughter, she has got married, my lord, out of that amount. Now only lump sum amount of nowadays It is not impossible, my lord. 18,000 or 21,000 they have said. But in my bank statement, I have shown that, my lord, it is only 14,000 something, my lord.
So, Mr. J.K. Goswami, Learned Counsel appearing for the respondent members.
All the respondents.
Learned Standing Counsel, APDCL appearing for the respondents. After hearing the preliminary submission of Learned Counsel for both the sides, this court is convinced that this matter would require a full-length hearing. Admit the repetition since the parties are already represented, no formal notice is required to be sent in this. Registered.
Next week, my lord, I'll represent. Next week and date, my lord.
The first week of May 2024. You come prepared.
Suicide while he was in service.
Hmm.
After his tragic death, his wife has taken everything, nearly 14 lakhs at a time. And now she is also taking all the monthly salaries and other allowances, paying nothing to me. I am a widow of 73 years old. And I was dependent upon the income of my deceased son, Arup Kumar Das. The other day, Lordship directed me that what is my income, etc., that I have submitted. I received 10,365 as the pension from my deceased husband. But that is not enough. I need 36,000 rupees per month for my medical expenses. And I have annexed all the medical papers, including bills of last 6 years. And only receiving 10,000 per month, 10,000 plus per month. So that is not at all enough. So I have brought everything on record. And there is no such rule that wife will get everything. Mother is the first class legal heir, and there are so many judgments of the Honorable Supreme Court that even though the nominee is met in favor of wife, other successors, as per Hindu Succession Act, they will get all the shares if they are dependent upon that person. In that view, my lord, Arup Das has one son, and that is widow. So I have claimed here 1/3 of the salary benefits which she is getting now, and also 1/3 of the 14 lakhs which she has already received, but given me nothing. So that is my prayer. And in support of my submissions, my lord, I have also brought some citations. I have given a note. Lordship may kindly say this judgment is enough, I think. Even then I have also some other judgments that I have given already there. Now, Lordship will kindly see para 13 to 20. 13 I am reading, my lord. The appellant submitted that according to the settled legal position crystallized by the judgment of Sarvati Devi Supra, the principle of law is that nomination is only the head which accepts the amount, and the nomination does not confer any beneficial interest in the nominee. In Sarvati Devi Supra, this court has laid down that a mere nomination does not have the effect of conferring to the nominee any beneficial interest in the amount payable under the life insurance policy on death of the insurer. The nomination only indicates that a hand which is authorized to receive the amount on payment of which the insurer gets a valid discharge of its liability under the policy. Lordship now would see para 16. Learned Counsel for the appellant also placed reliance on a division bench judgment of the Delhi High Court in Ashok Chand Agarwala versus Delhi Administration and others. This case related to the Delhi Cooperative Societies Act. That High Court, while following the Sarvati Devi case, held that it is well settled that mere nomination made in favor of a particular person does not have the effect of conferring on the nominee any beneficiary interest in property after death of the person concerned. The nomination indicates the hand which is authorized to receive the amount or manage the property, or the amount, as the case may be, can be claimed by the heirs of the deceased in accordance with the law of succession governing them. The controversy involved in the instant case is no longer res integra. The nominee is entitled to receive the same, but the amount so received is to be distributed according to the law of succession. Para 19 now, Lordship would see, in view of the clear legal position, it is made abundantly clear that the amount in any head can be received by the nominee, but the amount can be claimed by the heirs of the deceased in accordance with law of succession governing them. In other words, nomination does not confer any beneficial interest on the nominee. So Lordship, in that view, the Succession Act would apply. Now Lordship would say, as per section 8 of the Hindu Succession Act, the mother is, I have given a short note here before the bench is said. So as per
Just one
section,
minute, you are saying she is receiving salary. Salary is not the word, it's a pension. How can a deceased person receive salary?
no, nowadays government policy, every thing who is the employee was getting during his lifetime, everything is paid to the nominee. That is why. So now as I was dependent on my son's income, 10,000 is not around Lordship is over. I am 73 years of old age. And
Everything is paid to the nominee as per some scheme.
that is, my lord, they can.
Which is the scheme?
In a nomination paper, they sign a paper that.
Mr. Mahmood, if you don't show me the scheme, then don't argue on that. I will not be able to mention about it. If there is any such scheme which permits it, then do you have a copy of the scheme?
No, I have no copy. But it is guided by the section 8 of the Hindu Succession Act. Parties are Hindus. So in that view, my lord, the mother is the first class
Hindu
legal heir.
Succession Act refers to property.
Property also
Pension
includes.
is not a property.
Property in a broader sense, well, it should be taken a broader meaning. Property includes everything, including monetary benefits. That is my humble view, subject to correction. Now, thing is this, my lord, as I was dependent mainly on the income of my deceased son, and she filed a case against me. Actually, I committed suicide. There are so many things. I do not want all this. I have also annexed certain papers that she filed a case against my son, and he, being a teacher, respectable family, he has ultimately committed suicide. Just after suicide, she has come and has taken everything. So my submission is this, as because she is the wife, there was no legal divorce. On the other, there is also son. I am the widow, old aged mother. How many years I will live? 73 years. So during my lifetime, 1/3 of entire benefits, which she is now receiving, should be provided to me. And my prayer is well founded because I have annexed every document. What pension I am getting as SBI account, it is deposit account that I have.
Your client is getting family pension.
I am a family pension from my deceased husband. 10,300 that I have given in my additional affidavit, my lord. Kindly see my additional affidavit, which was filed by, as per your
Mr.
last.
Nayak, any decision on this, in these matters? Which is that act? You got the copy? Have you got the copy, Mr. Mohammed?
Lordship, may I point out one thing?
Do you have the copy of the
No,
act?
Lordship. No, Lordship. Just pointing out a thing, Lordship. Prior to approaching this honorable court, the petitioner approached under the
You are
pronoun
appearing
that.
for whom?
I'm appearing for the private respondent, Lordship, the wife. Prior to approaching this honorable court, the petitioner approaches the authority concerned under the pronoun act, Lordship. That prayer has been rejected. And the petitioner is earning, she is a pensioner, she is having an income. That facts has been suppressed in the petition, Lordship. And after I file my affidavit, then they come up with all these materials also. And in the proceeding before the authority concerned, Lordship, the district elementary education officer, the respondent number 7 undertook to maintain the petitioner on her medical expenses, Lordship, as because he is having income, Lordship. It is, I have annexed all the documents, Lordship.
So your client is ready to.
On medical expenses in the document itself, Lordship, page 26 of my affidavit, Lordship. Page 26, Lordship, second paragraph. Second. Six of my affidavit.
There is an additional affidavit only.
No, Lordship, affidavit in opposition filed by the respondent number 7. Start from page 18, running page 26.
Just check where is it? Affidavit of opposition filed by respondent. Yes, running page.
Running page 26, Lordship.
Yes.
Second para, Lordship.
Hmm.
May I read, Lordship?
Yes.
In this connection, it may be mentioned that the widow of the deceased late Arup Das submitted a letter that the undersigned mentioning you are a class 1 government pensioner and you have also 2 earning sons who reside along with you under the same roof. On the other hand, your deceased son had left a bank loan which is now being prepaid by your daughter-in-law from her CPF, but she agreed to look after you for medical purpose.
Hmm.
That is the undertaking, Lordship. For medical purpose, she undertook to look after. And on the
So how is she being looking after the petitioner for medical purpose?
now she is being looked after by the other 2 sons of the petitioner as on today. Other son, they are also earning. There are 2 other sons of the petitioners. She is not solely dependent on the income of the deceased Arup Das. And your Lordship, on the last occasion, directed to file an affidavit to the effect that whether she was solely dependent on her deceased son. That statement is not there, Lordship. She is not solely dependent on the income of the deceased son, neither in the petition nor in the additional affidavit.
And respondent number 7 is not remarried.
Not remarried, Lordship.
And she has a son.
Yes, Lordship.
School-going son.
School-going son.
And what is she receiving as pension?
No, Lordship, as of now, as per my instructions, he is not receiving anything because of this pendency of this litigation. Only the amount of the 10 lakhs or 11 lakhs, which I have mentioned in my affidavit, that amount she has received also.
You will get the full.
So she is not receiving it.
You will get lots of standard.
Acha, now,
My reply is there.
Mr. Mahmood, why don't you let
Yes.
the court, please take your seat. How will you take care of the medical needs of the petitioner?
Lordship, that instruction I'll have to take, Lordship.
Hmm.
That instruction I'll have to take, Lordship. She is ready. I have talked with her also. She is ready for the medical purpose. But what would be the way and method or what would be in what manner she would be taking care of that instruction I'll have to take, Lordship.
And which is the provision in this?
That is the earlier
What was the salary drawn by the deceased?
Lordship,
Do you have that?
I inquired, but she is not having any idea, Lordship. Lordship may keep the matter fixed on any other day, Lordship. I'll take the detailed instructions.
And where is the order asking them to clarify whether the,
Lordship, last order.
that is order dated?
Order date of 19/6/23, Lordship.
The additional affidavit has been filed.
Filed, Lordship. And there it is not mentioned, Lordship. Only the medical bills has been annexed, Lordship. And the fact of receiving pension by the petitioner, that was withheld in the while filing the petition, Lordship. Now that has been disclosed after we brought it to the notice
That
of
is
petitioner.
disclosed as per honorable court's order.
No, Mr. Mahmood, where is the statement that she was solely dependent on deceased Arup Das?
Actually, my lord, I have two sons, but they are unemployed.
Hmm.
They are unemployed, but I cannot make this because sometimes they help me, but they have no permanent income. So I cannot say
So
anything.
what do you say? She will take care of your medical expenses?
Yes, 36,000 I have paid the bill per month. If she pays that, I am satisfied. But she only says, but paid nothing. She has received 14 lakhs. As per her own affidavit, she has received 14 lakhs. I am on record.
No, that you won't get. I'm making it very clear. You can't claim it as a property right. That's not possible.
So out of 14 lakhs, she has given me nothing. Now she says, I will provide medical expenses. But till today, not a single paisa is given to me.
Lordship, I'll
So
have to take
if he
instruction.
fails,
I'll take instruction.
I am ready to accept because I do not want. How many days I will live?
Mr. M.U. Mahmood, learned counsel for the petitioner, has addressed elaborate arguments in support of the prayer made in the writ petition, but submits that if the respondent number 7 takes care of her medical needs on month-to-month basis, then she would not have any further
Yes.
claim in the matter. Stop.
Amounting to 36,000. I have paid.
36,000 every month, it will not be 36,000.
Yes, my lord, average
yes,
36,000. I have annexed the bill.
No,
my-
Lordship, the
Of last 6
petitioner has
years.
annexed the bills from 2018, Lordship, till
Yes.
today.
Yes.
So that is not.
To substantiate my claim, 2018, I have annexed the
Son
bills.
died when? Arup Das died when?
My lord. He died.
Mr. Mahmood, I would request you to be a little honest. You see, that is when the problem starts. If you are always trying to extract something for your client, then there is a difficulty. Then we will also be very technical. And you know, the judges can give an answer this way or that way in technical matters. You see, there should
Actually,
not
at
be an
that
attempt
time,
to extract. Because
She is
she
an
also-
old man, many things she did not, could not disclose, that
The
is.
moment you say 36,000 every month,
On record,
the judge, you have lost the judge in this case.
ballot.
You have lost this
Bills are
sympathy.
before lordship ballot. Bills
This
are
is
not
a
prepared by
commercial
me.
deal. We'll treat it like this. Your client is simply trying to extract money from the. We'll take care of it then.
Arup Das died on 13/7/18.
So, since all these days, who has taken care of our medical needs?
Medical and other needs, my lord. A son, lordship is aware, a son helps in every time.
So you
Lots-
obtain instruction and
lots-
tell us. At responding to the above, Mr. D. Das,
D. Das.
learned counsel for the respondent number 7, prays for 2 weeks' time to obtain instruction from his client and appraise this court as to in what manner she would be able to take care of or look after the medical requirements of the petitioner. Mr. P. Nayak, learned standing counsel, Finance Department, Assam, is present on behalf of the official respondents. On the request of Mr. Das, this writ petition is directed to be listed again on 15th of February 2024 as a fixed part-heard matter.
Yes.
Mr. Mahmood, please, I expect you to be an officer of the court in these matters. Please be honest about what is happening. Don't try
No, my
to
lord.
extract, because the moment you try to
No,
extract,
lordship,
you
my
will
lord.
get, you will not
Lordship has-
get 10% of what you will.
My lord, lordship, this is an old man.
Oh.
Old man, see what she said me, I have written that. And there are supported documents. How,
The experienced counsel who have a standing in the bar and pretty senior, the court expects them to act as officers of the court, not merely
that I
parrots,
lordship, my lord.
not merely as parrots of their clients. I am only telling you that. Yes.
All right.
23.
My lord, the petitioner, while serving as assistant research officer, the disciplinary proceeding initiated, my lord, in the year 2016 and ultimately culminated by an inquiry report, which says, my lord, the charges level against the charged officer is not proved. That your lordship will find at page 42.
So petitioner has been terminated.
Not terminated, but the inquiry was initiated, inquiry, my lord, the finding is that all the charges level against the petitioner is not proved. So inquiry closed. So at this stage, my lord, now a fresh de novo, my lord, inquiry has been initiated by a different inquiry officer, page 49. This they cannot do, my lord, your lordship knows that rule.
Cannot do, so we'll admit it and list it in usual course for hearing.
My lord.
Interim order to continue. Yes. Yes, yes. Why should we devote urgency in this matter right now? Your
No,
client
no,
is protected. There's a stay order.
Yes, my lord, this is clear.
Hear it. Obviously, it is not permissible.
It is not permissible. There is a
Heard Mr.
case
VD, the
directly,
senior
my lord.
counsel appearing for the writ petition, also heard Mr.
P. Handick, my
P.
lord.
Handick, Learned Counsel appearing for the
1,
respondent.
2, and 3.
Numbers 1, 2, and 3. How many respondents here?
3, my lord.
By referring to the materials on record, Mr. Das, Lannis senior counsel for the petitioner, submits that after a departmental proceeding has been closed on the ground that charges brought against the petitioner could not be proved in the inquiry proceeding, a de novo inquiry on the same set of charges is impermissible in the IF law. Mr. Handick, Learned Departmental Counsel, on the other hand, has contested the said submission of the petitioner's counsel and has prayed for a detailed hearing of the matter. In view of the above, admit the writ petition, since the parties are already presented, no formal notice is required to be sent. Register to list this case for hearing in usual course. Interim order passed earlier to continue until further orders. All right. No, but these are, see, completely unnecessary, Mr. These are completely unnecessary litigations. It's well settled law. You can't do it.
May I please, your lordship? My lord, there is a order of this honorable court 13/12/2023, my lord. The direction to the authority, my lord, and private respondent to file affidavit in this case. But till date, we have not received any copy, my lord. And moreover, my lord, I'd like to draw your lordship kind attention, my lord, the order 7/6/23 first. The first order, my lord.
Lordship, before your counsel, before the council continues and Lordship progresses with this case, well, can it be taken after some time, Lordship? There are some instructions which Council D. Upamanya has received. He's on legs. He'll be back here. Perhaps it would be better if.
Call him in.
Yes, Lordship.
in
Yes,
15
Lordship.
minutes.
Absolutely, Lord. Much obliged, Lordship.
Item 26.
On last occasion, they have directed to file affidavit, my lord, matter related to compassionate appointment, my lord. Relating to compassionate appointment. Earlier, there was also a round of litigations, my lord. Petitioner fighting for his compassionate appointment since the year 2000.
Who has died? Who has died?
My father died.
When?
13/2/2015. 2005, 13/2/2005.
So you want compassionate appointment after 19 years?
My lord.
Very strong case he has. What do you want to do? You want the matter to be
Now
closed
it's
today?
because the second round of litigation, my lord.
19
There
years.
already is in direction that has been violated.
What direction is there?
To make a consideration and intimate me. That intimation was not.
We have considered his case, Lordship. We do not have vacancy in our department, Lordship. We are taking up the matter with the other administrative departments, Lordship.
And the order
Lordship,
reflects, our order reflects
The
that
latest instruction
he was,
that I have received yesterday.
his appointment for compassionate appointment was considered by the DLC for the year 2007-8. There is a clear vacancy of grade 4 post, but they have not considered my case. It is also reflected in the
You file
order.
your affidavit. You are appearing for whom?
Yes, Lordship. We'll file our affidavit, Lordship.
You are appearing for whom?
For the agriculture department, Lordship. All the departments.
Mr. D. Bora Learned Counsel is present for the petitioner. Miss
R.
R. Bora Learned Standing Counsel Agriculture Department appearing for.
2, 3, 4, 6, and
Response
7.
numbers 2, 3, 4 and
6 and 7.
2, 3, 4, 6 and 7 submits that some instructions have been received by her and therefore she be permitted 3 weeks time to file
Gotcha.
affidavit. Considering the nature of controversy involved in this case, affidavit from the departmental authorities would be necessary for a just decision of the issues raised by the petitioner. As
Well,
such,
particularly vacancy for the period 2007-8, to whom they appoint.
as such, this writ petition is directed to be listed again on 7th of March 2024 as a fixed item The respondents to file counsel affidavit on or before 4th of March 2024 by serving advance copy upon the petitioner's counsel. It is made clear that the counter affidavit to be filed shall also indicate the vacancy position in the department during the relevant point of time. That the matter be listed.
My lord, may I pray for another date on 7 March? There will be some difficulty, my daughter's exam, my lord. Therefore, kindly another.
11th March.
That is also same, my lord. In between 7 and 11.
In between 7 and 11 is on a Sunday.
On my lord, 6 of March or
No, not possible. 13th.
that is also same, my lord.
On 5th of April. Yes.
Obliged.
And affidavit can be filed by 18th of March. Yes.
Lordship, instructions in this matter are awaited. Lordship may grant us 3 more weeks.
Well, pensionary benefits has not been released in terms of the earlier order. We have also filed a contempt case number 762 of 2023. Your Lordship will direct both the writ petition and the contempt petition to be listed together.
What is the contempt case number?
762 of 2023.
All right. How much time you want?
Lordship, 3 weeks.
So we'll list it on a firm date along with the contempt case.
Yes.
Mr. B.D. Kaul and senior counsel, Mr. Agarwal is present for the petitioner. Mr. I. Bhattakur, learned standing counsel, Forest Department, has appeared for the official respondents and prays for further 3 weeks time to obtain instruction and file affidavit. Mr. R.K. Talukdar, learned standing counsel, AG Assam, is present on behalf of the respondent number
5, my lord.
5. On the request of direct counsel for the parties, this matter is directed to be listed again on 11th of March 2024 along with contempt case number 762 of 2023.
Item 28.
Your Lordship, this present contempt petition is directed for non-compliance of order dated 8/3/2022. If I may take your Lordship to page number 16.
Page number
16. 16 of the contempt petition.
Yes.
Paragraph number 16.
Yes, please.
The order dated 1/5/2012 issued by the Ministry of External Affairs, Northern Division, clearly shows that the BCA payable to central and state government deputation is to Bhutan for officers drawing grade pay of 6,600 per month and above, but less than rupees 8,700 per month, with effect from 1/4/2011 would be 93,031. The letter dated 23/11/2012 issued by the Ministry of Road Transport and Highways, Road Roads Development Board, states that an ad hoc increase in BCA with effect from 1/4/2011 payable to grave employees serving in Bhutan under Project Dantak in accordance with Government of India Ministry of External Affairs dated 1/5/2012 and even number dated 24/5/2012 for officers of central and state government of India during service on deputation to Bhutan would be as per the chart given. Now, as per the chart given, the letter dated so and so, the BCA rate with effect for 1/4/2011 for officers drawing grade pay of 6,600 per month and above, but less than 8,700 per month is 82,900. As a perusal of the two different figures given for BCA in terms of order dated 1/5/2012 and letter dated 23/11 shows that the mistake seems to have been made in a letter dated 23/11/2012. In view of the fact that the order dated number so and so dated 1/5/2012 has been provided that the BCA should be 93,031 and the same has been accepted in the letter dated 23/11/2012 issued by the Ministry of Road Transport and Highways, the BCA rate payable to the petitioner with effect from 1/4/2011 cannot be 82,119. It should have been 93,031 per month. Next page, Your Lordship, paragraph number 18. Be that as it may, the letter number so and so dated 6/4/2015 issued by the Undersecretary to the Government of India, Ministry of Defence, which is annexure R2 of the affidavit filed by the respondent number 1, states that the President of India has sanctioned the ad hoc increase in BCA with effect from 1/4/2012 payable to grave employees serving in Bhutan under Project Dantak in Bhutan in accordance with the Government of India Ministry of External Affairs dated 5/6/2014. This is important, Your Lordship. For officers of the central and state governments of India during service on deputation to Bhutan. Letter further stated that revised rates of BCA at rate of 8% with effect from 1/4/2000.
So what has happened? He has not been paid BCA.
Not that rate as per this 5/6/2014. Now, if I may place this may
Just a minute. The direction is to pay him BCA at the rate of 99,608
yes,
per
yes,
month. Plus, if there is any enhancement
yes,
subsequent to
yes.
1/4/2013, then that is to be paid.
Yes, yes,
That has not been paid.
not paid, Your Lordship.
Where
It
is the
was-
statement that it has not been paid? Where is the statement in the contempt case?
Because this whole writ petition is directed.
I am asking you a question. Please answer it.
Yes, yes.
Where is the statement?
Further at paragraph number 3, page 4.
Yes.
The petitioner humbly begs to state that the petitioner received a certified copy of the judgment order dated submitted the certified copy of the said judgment and order for further necessary action on 14/3/2022 via email dated so and so. The petitioner submitted a scanned version of certified copy of the order due to ongoing COVID-19 pandemic instead of the hard copy.
Yes,
of
you
the
are
petition.
appearing for Lordship. I'm appearing for the respondents. Lordship, may kindly see the affidavit filed by the respondent number 4. And I take your Lordship to paragraph 2 and 3 of my affidavit. To Lordship, the direction which the Honorable Court has given that I have quoted in paragraph number 2. And paragraph number 3, Lordship will see. It is, if I'm not wrong, Lordship, running page 33. Paragraph 3, the deponent begs to state that in terms of the Honorable Court's order dated 8/3/22, the Pay and Accounts Office, Ministry of Defence, Government of India has worked out the details of the amount due and paid to the petitioner for his period of posting in Project Dantak with effect from 26/7/13 to 3/8/2015 and communicated the same to the Headquarter Director General Border Roads, White so and so. Accordingly, it appears that the petitioner has already been paid a sum of rupees so and so, including arrears towards Bhutan compensatory allowance against the entitlement of rupees 24,19,668 for the period 26/7/2013 to 3/8/2015. The payment has been made at the rate of 99,608 along with enhancement of BCA at the rate of 1,07,344 and at the rate of 1,14,439 as arrears entitled in the months of October 2013, June 15, and October 2016. I've given a statement, Lordship, at Annexure 1, page 37, Lordship, when the arrears were given. So, Lordship, in fact, as per our calculations, 16,698 has been paid in excess to him.
So is there any rejoinder of this affidavit?
No, Your Lordship.
We'll close it then.
No, Your Lordship, I'd like to file a rejoinder.
No, sorry.
Because why, Your Lordship, if I may place this two particular OM, one is from the Ministry of External Affairs. And
Mr. Bora, you have to understand, this is a contempt proceeding.
I understand, Your
It
Lordship.
is not your writ petition.
I understand, Your
The
Lordship.
court is of the view that they have made a statement saying that we have complied with the court order.
But
If
that
you are still agreed to file another writ petition.
But that is what, Your Lordship, the problem is, Your Lordship, here in the, if Your Lordship peruses through the judgment, at page number 90, page number 17, they have stated that because on the day of the
No,
argument,
have you not received this amount?
that I have already received, Your Lordship, that's why I filed a writ
But you are not
petition.
satisfied with the amount.
No,
Heard
because that,
Mr. D. Bora, learned counsel for the petitioner, also heard Mr. R.K.D. Chaudhary, learned counsel appearing for the respondents, who has invited the attention of this court to the statements made in paragraph 3 of the affidavit filed on behalf of the respondent number 4 to submit that the amount has already been paid to the petitioner in terms of the direction of this court, and therefore the order of this court has already been complied with. Full stop. It further appears from the statements made in paragraph 3 that a sum of rupees 16,698 has actually been paid to the petitioner in excess. However, the said stand of the respondent has not only been strongly denied by the learned counsel for the petitioner, but he submits that although he has received the amount as projected in the said paragraph, yet the petitioner is not satisfied with the amount. Full stop. If the petitioner is not satisfied with the computation of the amount, that, in the opinion of this court, would give rise to a fresh cause of action. And therefore, the aforesaid aspect of the matter cannot be dealt with in a contempt case. In view of the above, by granting liberty to the petitioner to agitate grievance, if any, still surviving pertaining to the correctness of the computation of amount to be amount paid to him by the respondents in terms of the court's order. This contempt case stands closed.
Your Lordship,
Matters cannot be kept in.
Your Lordship's liberty may be given to file a review because this particular OM was not placed before the Honorable Justice Singhal judge.
They have already implemented. You cannot file a review now. The order has been implemented.
Your Lordship, this particular OM was never placed, Your Lordship.
You cannot prefer a review against that order. An order which has been implemented cannot be reviewed. There are orders of the court. Mr. Bora, the problem is nowadays people don't do the homework and study the law. They just come and say anything to the court. An order which has been implemented, how it can be reviewed? There are a number of judgments of this court on that.
Your Lordship,
You are not aware of those judgments. That's why you are making this.
if I have to, if I may be wrong, Your Lordship, this particular OM, relying on which they have said that I have received 99,000. They are relying on this Ministry of External Affairs letter. Ministry of External Affairs letter says 1,10,000, but they are saying that is why I approach Your Lordships, and Lordships said that yes, there is a mistake because this particular rate keeps on getting enhanced every year.
Correct.
And this particular, the rate that which the department has actually relied upon, Your Lordship, is the Ministry of External Affairs letter. Their own letter says so. That's why I wanted to place it, Your Lordship.
You want to place it where?
Before Your Lordship, because
You cannot do it. Because the order of the learned judge did not mention which OM to be relied upon.
that's why Your Lordship, the learned just said that any further enhancements as per the.
They have done it what they have felt is correct. This cannot be dealt with in a contempt case.
Very well.
Add one more line earlier. What is significant to note here in that the petitioner has not filed any rejoinder affidavit. Be that as it may, that was a fresh cause of action, etc. You can agitate it, but you have to get these things clarified when the order is passed. In a contempt case, you want these things to be dealt with.
No.
Mr. Bora, I expected you to say in the beginning that they have paid the amount, I am not satisfied. Give me liberty to agitate it, close the matter. But you will not do it. You will push for something which is not permissible in the law.
Very well.
And till the time the judge puts things down, you will go on, you will take a chance. How can these things be agitated in a contempt case? Is it permissible? You tell me.
Because I was only on a further enhancement part. That's what. Anyways, Your Lordship.
Further enhancement part means?
As Your Lordship, in the single bench, single judge order for any further enhancements. So I was on that particular part. So anyways, Your Lordship.
No, any further enhancement, there has to be a clear determination on that if you are not happy with the amount. In a contempt case, we cannot pass any further direction. That's the law.
Very well, Your Lordship. Then I have to, liberty may be given to file a fresh
It has
petition.
been given.
Very well, Your Lordship.
It has been mentioned that it gives rise to a fresh cause of action. File another writ petition, this time be more specific. You have to make a claim that this is my claim, this is what I am expecting. Is it not?
That is.
And you have not filed any rejoinder?
Actually, I wanted to seek time to file a rejoinder because the calculation.
Mr. Bora.
Anyways, Your Lordship.
You know when they filed this affidavit?
Long time back. But the petitioner resigned, he retired. And so I had lost contact with him. So his earlier number was.
There is nothing personal about it. The petitioner has not filed the rejoinder.
That
All right, all
that is
right.
true.
Item 29 and 30.
Well, against the
Mr. Bora, don't take things personally. We are trying to only administer the course of the proceedings here, huh?
I'm always here to learn.
We have to be tough slowly. Things are otherwise not falling in line. Yes.
But against the judgment, we have preferred an appeal, Lord. And in the appeal, my lord, notice has been issued and
Which judgment?
this is the contempt matter, my lord. The
Judgment dated at
This
page
is obviously a contempt matter. Which judgment?
No,
have you preferred
judgment
in it?
dated 26/22, my lord, at page 12, my lord. You start from page 12.
starts from page 30, my lord.
ক'বলৈ বেয়া লাগে তো, এই judgment চাব। নকবা। Relevant portion at page 23, my lord, paragraph 19.
The appeal has been admitted.
Appeal, I have given the order, my lord. Notice has been issued in the appeal and in the interim prayer also, my lord. I have given the order, my lord. My learned friend, they have appeared.
When is it fixed?
But directed us to take steps
Then
in
we
take
will have
weeks.
to adjourn it today.
The rule has been.
Because of your lordship order, last order, my lord,
Yes.
1812.
Ah.
That's why this case is received, my lord, 1812 order.
I have given the order passing the writ appeal, my lord.
All right, so now today what is to be done?
Lord,
That's up to your lordship.
I prefer taking up this after 4 weeks, my lord.
Right. Heard Mr. S. Kotakil, learned counsel for the petitioner, also heard Mr. D. Nath, learned counsel appearing for the respondent who submits that the writ appeal preferred against the judgment dated 26/2022 passed in WPC number 7215 of 2018 is pending consideration of the interim prayer made by the state appellant, and therefore this contempt case be adjourned for 6 weeks, awaiting further orders to be passed in the appeal. In support of his above submission, Mr. Nath has also produced a copy of the order dated 18/10/2023, passed in writ appeal 398 of 2023, a perusal of which goes to show that the notice on interim prayer is also pending consideration. In view of the above, let this contempt case, let these matters, 2 contempt cases, be posted again after 6 weeks. If there is a stay order, we'll stop it, otherwise we'll proceed.
Lot. All.
So as per last order dated 8/12/2020, it is supposed to file an affidavit to bring on record the latest communication there.
Lordship, that communication was also put on record by last order.
No.
Beyond that, Lordship, we have not heard anything from the accountant general yet.
Lordship, we need 2 weeks time for instruction.
Who are you? You are appearing for?
Accountant general.
Mr. N.J. Gogoi, learned counsel is present for the petitioner. Mr. I. Botaku, learned counsel has appeared for the respond numbers.
1.
Respond number 1, Miss
J. Das on behalf of R. Ahmed.
J. Das, learned counsel appearing for the respond number 3. Praise for posting this matter again after 3 weeks so as to enable her to obtain complete instruction in the matter. Prayer allowed. Register to list this case again after 3 weeks as a fixed item.
Item 33.
My instructions, my lord, I was directed to obtain instruction regarding status of the DP. Actually, DP is not drawn because they have written to the on several occasions written to the Home Department to give the status of his arrest so and so. And for this also, my lord, 8 January 2024, DPC was held. But in DPC, they could not, my lord, take the decision because they have not received any status from the Home Department. Only for that, my lord, this matter is
pending. And otherwise, I have received an instruction, my lord, on 22nd. They have said that before his retirement, they will decide to promote him, my lord. Because he is eligible to promote in January 2024. Lordship kindly see. Paragraph 2. Following his arrest, so was placed under suspension. No departmental proceeding was initiated against him. And paragraph, last paragraph, my lord, last part 1. In a meeting of Departmental Promotion Committee held on 8/1/2024, it was decided that Food and Public Department, so department, right to whom department, political department to furnish a report whether any charges have been framed against so by CGM code, and on receipt of the report, matter of promotion of Hussain will be examined subsequently by convening a DPC meeting. Food, Public and Distribution Consumer Affairs Department desires to give Alta Hussain a fair opportunity for promotion by convening a DPC meeting and by considering his case in the meeting at the earliest before he is retired from government service attaining the age of supination. This is my instruction. They will take this decided. They will decide it, my lord, in the month of February, first week, second week, like that, my lord. Ultimately, they will give him promotion, but already they are waiting for instruction from the political department, Home and Political Department.
Lordship will fix it then in the first week of the February, let them have the.
Then we'll close it. by
Lordship
directing
will
them-
close it, my lord.
You take down. Heard, Mr.
A.N. Sharma, my lord.
A.N. Sharma, learned counsel appearing for the writ petitioner. I've also heard Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing on behalf of
And there are, my lord, respondent number.
respondent numbers 1, 2, and 3. Who is respondent number 4?
4 is private respondent, Dhruva Kumar Das.
None has appeared for the respondent number 4. Full stop. The writ petitioner hearing is serving as
Deputy Controller. Meteorological Department.
what is it serving as?
Serving as my lord,
Deputy Controller of Legal Meteorology.
yes, my lord.
There is no mention of it.
উল্লেখ করে না নাকি?
Where have you mentioned what is he working as?
Deputy Controller Meteorology, yes, mention this.
Where
Please
is-
to register the petitioner in service as Deputy Controller of Legal Meteorology, Food, Civil Supplies and Consumer Affairs. Page 8. Paragraph
Deputy
3.
Controller of Legal
Meteorology.
Metrology, comma,
Food,
Department of Food, comma, Civil Supplies and Consumer Affairs, comma, Government of Assam.
Yes.
The petitioner is due to retire from service on attaining the age of superannuation on 25/2/2024. The grievance of the petitioner is that although he is due for next promotion to the post of Joint Controller in the Joint Controller Legal Metrology, yet his case has not been considered by the authorities, although the person junior to the petitioner has already been promoted to higher rank.
Not junior, my lord.
Then who is responding?
That's what 4 is, my lord, he is holding the charge about joint duty
Has
because he
not
is in
been-
Guwahati headquarters.
Has not been considered for promotion till today by convening a DPC.
He is basically eligible in the month of January 2024. He will complete 2 years
Right.
as a deputy.
Taking note of the grievance expressed in this writ petition, this court had passed order dated 12/1/2024, requesting the learned government advocate Assam to obtain instruction and appraise this court if the case of the petitioner is being considered by the DPC prior to his retirement. In response to the above, the learned DA Assam has produced a copy of the written instruction dated 22/6/2024, which goes to show that the petitioner was earlier placed under suspension, but no departmental proceeding was has been initiated him till today. First up. although the petitioner was reinstated in service as Deputy Controller of Legal Metrology, bracket close zonal, yet his period of suspension from 29/9/2021 to 25/4/2022 had not been regularized due to want of certain relevant documents and particulars from the Home Department.
Home and
Home
Political.
Political Department, Assam. Post up. The written instruction dated 22/1/2024, however, categorically proposes that the case of the petitioner will be considered for promotion by convening a DPC prior to his retirement from service. Full stop. Mr. Chutia, learned additional senior government advocate Assam submits that the petitioner has become due for promotion only in the month, only on 12th of January 2024. Is it?
Yes, yes, my lord.
12th of January 2024. However, the department is contemplating to consider his case for promotion as per the projection made in the written instruction. Stuff. Mr. Sharma submits that if the case of his client is considered for promotion prior to his retirement, then the petitioner will be satisfied in the matter. Petitioner will remain satisfied. Having heard the submissions of learned counsel for both the sides and taking note of the projections made in the written instruction dated 22/1/2024, issued by the Secretary to the Government of Assam, Food, Public Distribution and Consumer Affairs Department, Dispute. This writ petition is being disposed of by providing that the departmental authorities may convene a DPC for considering the case of the petitioner for promotion to the next higher rank of Joint Controller of Legal Metrology within 3 weeks from today. It is made clear that the consideration shall include not only the petitioner, but other departmental candidates who may be in the zone of consideration. And this would be subject to fulfilling the eligibility norms for being considered for promotion under the rules. First off, facilitating the above process, the respondents may take all necessary steps for regularizing the period of suspension of the petitioner for the period mentioned herein above. With the above observation, the writ petition stands dismissed.
Obliged, my lord.
May it please your lordship. My lord, here is a case your lordship will find. The petitioner was appointed as a compassionate appointment in the office of the executive engineer, my lord, Badarpur. Now, the appointment was on 8/5/2023. She joined on 16/5/2023. On 19/5/2023, head clerk of that office said that you give your appointment letter, there need to be some correction. Now, the next day when she asked for the letter, the head clerk said that he refrained from giving it back, saying that you don't come from tomorrow in the office. Now, this is her position, my lord. And your lordship can see even at this stage, what is the role of the government advocate? My lord, they have deceived us and they have taken the court for a ride. They are not filing their affidavit. In the last occasion, your lordship, my lord, that order your lordship kindly see.
Lordship, our instructions are still awaited. Kindly grant us 1 week time.
My lord, may I pray that these officers 2, 4 and 5, they may be called for to appear before this honorable court and say, what is the problem?
Lordship,
They don't have any respect for the court's order.
no, your lordship, last 1 week time to file our affidavit.
No, you are appearing for whom?
Water Resource Department, respondent 2 and 4.
There is a direction from the court to file affidavit.
Yes, your lordship.
19/12/2023, your lordship's order.
Lordship, we have not received our proper instructions.
That's all right. Have you communicated to them?
Yes, your lordship.
Then we'll ask the chief engineer to come.
Lordship, Lordship, have received our instruction, but the instructions are not in proper
Just now you
way.
said you did not receive instruction.
Lordship, proper instruction, we have not received the
Uh,
proper instruction.
Tomorrow we'll take up the matter. If the affidavit is not filed by 10:30, there will be personal appearance of chief engineer. Whatever you do it. Mr. S. Dattal,
Yes.
and senior counsel for the petitioner. Also peruse the order dated 19/12/2023, by means of which this court had directed the official respondents to file counter affidavit on or before 22/1/2024. However, today when the matter is posted, it appears that no such affidavit has been filed till today. If that be so, this is a fit case for directing personal appearance of the concerned officials due to non-compliance of the court's order. However, at this stage, Miss, your name?
D. Jane.
D. Jane, Learned Counsel, appearing for the Water Resources Department, has got time till tomorrow morning at 10:15 PM to file the affidavit by serving advance copy upon the petitioner's counsel. On the request of Ms. Jane, registry is directed to place this case again for orders as a fixed item tomorrow with the date 25/1/2024 by tagging the affidavit, if any, filed by the petitioner. Now, tagging the affidavit not written. So tomorrow if the officers don't come, if the affidavit is not filed, then we'll direct personal appearance, we'll inform it.
Much obliged.
Here I pray for 2 weeks further time, lordship instruction.
My only prayer, my lord, date may be fixed, my lord.
Sorry?
Date may be fixed.
Date may
lordship.
be fixed.
I had Mr. P.K. Dattal, Learned Counsel for the petitioner, also had Mr. D. Upamanyu, Learned Standing Counsel, Health Department, Assam, who prays for further 2 weeks time to file affidavit. Prayer allowed as a last chance. On the request of Learned Counsel for the parties, let this petition be listed again on 21/2/2024 as a fixed item. In the meantime, affidavit be filed by the department
Highly obliged.
by serving advance copy upon the petitioner's
My
counsel.
lord.
Please.
There is no hearing.